What is collective labor law? Collective labor law is a branch of labor law that regulates the relationship between employers and workers when they act as a group. It mainly applies through trade unions. It protects collective rights such as freedom of association, collective bargaining, and the right to strike. Why is collective labor law important? Collective labor law is important because it balances the relationship between employers and workers. Since employers often have more power, this law creates mechanisms to ensure fairness. It promotes social justice, protects human dignity, and helps maintain labor peace by providing legal ways to resolve conflicts. Legal framework in Colombia. In Colombia, collective labor law is regulated in Articles 353 to 484 of the Substantive Labor Code. These articles establish the legal framework for collective labor relations. They regulate trade unions, collective bargaining, and the right to strike. This ensures that collective actions are carried out according to the law. Main topics. Collective labor law is based on three main pillars. First, trade unions which represent workers. Second, collective bargaining which allows negotiation between employers and workers. Third, the right to strike used when an agreement cannot be reached. These elements structure collective labor relations.
Hi guys, today I go to talk to you about unions in the field of the labor law. Guarate is a group of workers who defend their rights and ensure decent conditions in the company through dialogue dynamics between employer and workers. Types of trade unions. Under Colombian Substantive Labor Code, there are four main types of trade unions. And under union is former workers from the same company, even if they perform different tasks. And industry unions includes workers from different companies but within the same economic sector. A craft union encompasses workers who share the same profession or trade, even if they work in different companies. Finally, a general union is formed by workers from different professions, but only when there are no enough workers to a more specific type of union. Constitution and registration. According to the Colombian Substantive Labor Code, a trade union must be formed by at least 25 workers. The union is created through a founding assembly, where the delegates are approved the board of directors is elected. After the constitution, the union must register before our Minister of Labor, but submit the required documentation. However, registration does not create the union. It only grants public recognition. Trade union protection. In Colombia, trade union members, especially founders and union leaders, are protected by what is known as fuero syndical. This protection prevents employers from dismissing or transferring without pure authorization from the labor judge. It is considered a form in reinforced hope stability, designed to protect freedom of association and union activity. Without judicial authorization, this similar is ineffective. Rights and duties of trade unions. Trade unions in Colombia have several important rights. First, freedom of association, which allows the workers to form and own unions without the state interference. Second, union autonomy, means thrive on their own beliefs and elected representatives. They also have the right to collective bargaining, to present their members, and declare a strike within legal limits. At the same, unions have duties. They must operate democratically, comply with the law and their internal status, and ensure transparency in the management of union resources.
Hi, my name is Geraldine. What is collective bargaining? It is the right of working and employer to negotiate working conditions. It is regulated by the Congreso de la República de Colombia in the Substitute Labor Code. It is also a right protected by the political constitutions of Colombia. Its main objective is the improve wages, benefits, and the working conditions. List of them. It is document submitted by the union to the employer to begin negotiation. It includes requisites related to salary, working hours, benefit, workplace well-being. The process officially begins once it is submitted. Stage of the process: 1. Submission of the list of demands. 2. Direct settlement stage. Negotiate between the parties. 3. Mediation of no agreements right. 4. Strike or arbitration tribunal. The entire process is regulated by Colombian labor law. Collective agreement. It is the final agreement signed between the union and the employer. It is legally binding. It establishes working conditions for a specific period. It applies to union members. Legal effects. It is mandatory for the parties involved. It improves the condition of individual employment contracts. No compliance may lead to legal sanctions. It guarantees stability and legal security for the parties.
Article 429 of the Colombia Labor Code defines a strike as the collective, temporary, and peaceful suspension of work by workers in order to defend their labor and economic interests. The strike is a right that workers have to defend their labor interests, but the Colombia Labor Code establishes rules so that this right does not affect social or essential services. It must be collective, it must be temporary, it must be peaceful, it must have labor purpose. A strike is legal when it meets the requirements established in the Colombia Labor Code, especially when happens after its labor conflict is approved by the majority of workers and is correct of peaceful. Article 431 establishes that the strike must be approved by the majority of workers and must be declared with the legal time after the direct summons starts. During the strike, workers suspend their activities as a form of protest. By the most as peaceful, the life for this violence that marks to the company of forcing of their workers to participate. Article 430 prohibits a strike is essential public because their suspense might seriously affect the company. According to Article 450, when a strike is declared illegal, the employer might terminate the contract of workers who activity participate. In conclusion, the strike is a right, but it must follow the rules of the Colombian labor code to be legal.